In a little bit, in a couple of minutes, we're going live. Come on in, come on in. We're going to be broadcasting live on YouTube. So come on in, come on in. Attorney Keys is here and she's ready and she's waiting on you guys. It's like, yep, she's ready. There she is. She's ready and she's waiting. So can't wait.
Information. Got some great information to share with you tonight. So, thank you for carving out some time in your afternoon, after work, after school, after everything, just to come sit with me here for this next hour to learn how, we can protect, you and your family for having to go through probate, or to, answer, any of your questions that you may have had about probate, or estate planning, or, how do you avoid, how do you avoid this? How do you avoid that? So tonight, I'm praying that we can go ahead and answer a lot of questions for a lot of folks that may be experiencing, probate, that haven't experienced probate yet, so we want to try to figure out, how do we not have to go through that strenuous process of going through a probate? All we have to do is we have to take steps beforehand, because we're going to be proactive and not reactive, right? That's what the name of this game is: proaction versus reaction. We don't wait until our loved one passes away to start thinking about how are we going to handle the estate. We need to already have an estate plan in place, a plan. No plan is a plan to fail. So if you don't have a plan, then the plan is failure. So just know that whatever plan or lack thereof is a plan all in itself. So I'm excited to talk to you all tonight. And we're just gonna vibe, and I'm gonna, like I said, talk about probate. Then we'll get into a space where we'll answer some questions, and see if I can get you and your family the help you need if you're currently experiencing a property or assets that need to go through probate, or if you're looking to avoid probate, or if it's just for you yourself. What type of steps can you make to ensure that your estate is properly protected, and that the beneficiaries that you want to receive those assets after your passing, what can you do to make that process a lot smoother for them? So that that's what we're going to be focusing on tonight, just pretty much a smooth process when it comes to protecting our estates, and putting the proper things in place, so that again, we're not being reactive, we're being proactive when it comes to how do we want things to look once we're no longer here, and we're not in control of those assets that we want our loved ones to have. So right now we're streaming live on TikTok. We are on YouTube, and if you're here with me tonight in the Zoom, again, thank you for coming. Thank you for coming.
Okay, I'm gonna be admitting them now. Okay.
Okay. All right, Vivienne's opening up the doors on Zoom. Welcome, Patricia. Welcome, Joyce.
Welcome in, guys. Welcome in.
Welcome, Rhonda.
Welcome in.
Thank you for coming tonight. Thank you for coming tonight.
Well, we're going to have some fun. We're going to have some fun with Attorney Keys tonight.
That's right. We're going to have some fun.
I've been waiting a couple months to bring her on. Finally.
Looking forward.
Welcome in. I hope you guys have your questions ready for Attorney Keys.
Yes. I'm going to take some time just to kind of, talk about probate, for a little bit, talk about the different type of administrations, within the probate sector, talk about what it might look like, if you don't put some type of plan in place, how much is it going to cost you on the back end to go ahead and get a probate done, for any estate that you're looking to, to do that for. So that's what we're going to be talking about tonight. So, ladies, I definitely appreciate you for coming.
Thank you for enlightening us.
Hi, Neville. Thanks for coming. Thanks for coming to the Zoom tonight.
Hey, how you doing?
I'm well, and yourself?
I'm
Attorney
trying
Key, I
to,
think there's like a feedback on your end. Are you hearing a feedback like?
No, am I echoing? Because I don't, if I am echoing, I don't hear it.
I don't hear feedback. I'm sorry.
Okay, yeah. For me, I'm hearing kind of a echo.
You're probably so you got me. You have me running on YouTube. You have me running someplace else, and you have me running here on Zoom. So you're probably hearing it at all different times. Is that what it is?
Okay.
Hi, Trey Vinton. Thanks for coming tonight. We're just waiting on a few more people, to join. That way no one misses the information.
Say that
Hi,
again.
can you hear me? Can you hear me now? Is
Yeah,
that
I
is
can
Yes,
am
hear
I
I
you.
still?
can hear you. Hi. Hi, guys. Hi,
Hi.
Viv.
Hello, hi. Thanks for joining.
Welcome in.
No problem. I'm out and about, so I hope that's okay.
No, it's fine. No, it's fine. Thanks for coming. Thanks for carving some time out tonight just to have, like what I believe is one of the most important conversations, that any family can have, talking about probate and the proper estate plan that you need to put in place to avoid
Hi. That's all right. Do your thing. Do your thing. Do your thing.
all right. Did you want me to go ahead and get started, Vivian, or you want to wait for a few more people?
Yeah, let's wait a couple more minutes for them to
Let's do it.
come in.
Attorney Keys, will you also cover the Ladybird?
Yeah, the Ladybird. Yeah, we're going to talk about the Ladybird deed, which is which in the legal term for it is the enhanced life estate deed. So that's what it is, and that is one of the tools that you and your family can use to avoid probate.
Okay,
I'm
thank you.
sorry, what's your name? The attorney?
Keys. My last name is Keys. I go by Keys,
Keys.
Keys. Oh yeah,
Okay,
yeah.
Ms. Keys.
Keys.
I know we haven't started yet, but I reside in New York State, and I know things are quite different. So if you know, if the Lady Bird deed, if it's under a different name or if there's a different process within the state of New York, I would like you to expound upon that
So
at some point.
it's going to be a life estate deed no matter what state we're in. So like warranty deed, special warranty deed, quick claim
I'm
deed, life estate deed. So different places might have a different niche name for it, just because it became more of a term of art, depending on where you are. But the crux of it is it's a life estate. It's a life estate deed, and every single state, is going to have a lot. You can prepare and record a life estate deed to bypass probate if that deed is set up correctly. All right. Vivian's gearing up the presentation. So it looks like we're going to get started here in a little bit. Thank you
okay.
all.
So it's 6:35. We'll wait. We're gonna get started. So we're not holding up everyone else. And as they come in, yes, I will allow them to come in. So tonight, as you can see, our agendas on the screen. This is what we're going to be covering. And then we're also going to be taking questions and answers.
All right. All right. Do you want me to go ahead and get started, Vivian?
Yeah.
So, good afternoon, everybody. Thank you for taking the time out, out of your afternoon, your busy life, to just come and sit with me for about an hour and, and talk about probate, talk about the probate process. My name is Attorney S. Natasha Keys. Most people just call me Keys or Attorney Keys. I am a licensed attorney in the state of Florida. I do run my own practice. I specialize in the areas of real estate, probate, and estate planning. However, I am knowledgeable in all areas of the law. Some other areas of the law that I practice in, business law, and all of the governing documents that go along with that. The name of my law firm is Keys Law Group. So here's all my information here. There it is right there. So, you can screenshot or take a picture of the screen. That way that after this presentation, if you want to get in contact with me, there's a number and a QR code that'll get you directly to me. And then on the previous slide, there's an email address there as well, to ask me any questions. So today, like I said, today we're going to talk about specifically the probate process in Florida. However, no matter what state you're joining from, probate is going to be fairly similar, pretty much, across the board. So, what is probate, right? So probate is essentially the court's way of making sure a person's assets are transferred properly after they pass away. It's just the court's way of passing that property that was left in the estate, the person that passed away's name, to whoever those beneficiaries are. So in Florida, probate is supervised by a judge, which adds, structure, and everything like that to the process. Okay. Now there are a few types of probates that we go through. So one, you have the formal administration, right? And that's going to be the full process. So if your loved one has just passed away, typically you're going to have to go through a formal administration. That's where the estate, the state is typically, it doesn't have to be large, but when a person just passes away, you have to go through the entire probate process, and we'll get into that in a little bit. Now, summary administration is going to be for smaller estates. It is a faster option, but the one thing that holds true about the summary administration is typically the person has to be passed away for 2 years or more. Right, so that's the only way that we're entering into a summary administration. Everything else is a formal administration, and then you have something that's called disposition of the assets without administration. That means that these are items that typically don't have to flow through probate. Right, so we're talking about personal property, things of that nature. Those typically don't have to go through probate. So that gives me into my next speaking point. So not everything has to go through probate. So assets that are solely in the deceased name, those things typically have to go through probate, right? So just to kind of give you, a little timeline, of a typical probate process. So if we're doing a summary administration, you have a person that's passed away, 2 years or more. Those are going to be your shorter probate processes, right? It may take about, 3 months, 6 months, depending on the size of the estate, it might even take up to a year. But typically, a summary administration, we can get it done fairly quickly, just because there's not a lot of filing that has to be done. We don't have to follow all of the steps because the person has been deceased long enough where any creditors that needed to collect from that person, they've likely already done their due diligence and collected what they need to, collect. Funeral expenses are all taken care of. A lot of things have happened in 2 years after someone passing. So that's why the summary administration is typically a shorter process than our formal administration. So what is the first thing that we have to do? Once you find out that you have to go through probate, you do have to file a petition with the court. That petition with the court just kind of puts everybody on notice, all of the beneficiaries, anybody that may have, any claim to the assets that are being probated, lets them all know that, hey, we've opened up a process to go ahead and start taking these assets out of the estate and transferring them over to any beneficiaries. Right. So we file our petition, then we have something that's called a personal representative, and in New York and other states, it might be called the executor of the estate. So all of those are the same thing. That's the person that's in charge of the probate. They're the person that's in charge of making sure that all of the family is on one accord. All of the beneficiaries, are there, because all of these documents have to be signed off on. Now, costs can run anywhere between 3 to 7% of the value of that actual probate estate. So, you think so. What we're doing in this presentation tonight is we're trying to teach you how to avoid probate and the lengthy process of those costs. So I just want to give you all of the background about probate so that you can see how important it is. So you can see how important it is to go ahead and take those necessary steps to avoid it, so that your family doesn't have to go through this process, because, once we transition, we're no longer here. We're resting in peace while they're running in chaos, right? Because they just don't know what to do. So, what's the roles and responsibilities of the executor of the state or that personal representative? Again, is just to make sure that everyone is on one accord. They're my extension to the family, because I really just, I won't be able to, get with everybody. So I always have to have that one person that's in charge of the estate. And, they're keeping up with all of the family and making sure that everyone, the wishes are being carried out. All right. Now, if you pass away without a will, without a trust or anything like that, in Florida, that's called an intestate succession, which means that if you don't have anything in place, a will, a trust, any advanced directives, in the form of Lady Bird deeds or enhanced life estate deeds, the state that you live in will determine how your assets get passed to the beneficiaries. So, if you don't want the state deciding how everything gets dispersed after you pass, then you better make sure that you have some type of plan in place so that your family knows what to do when that time comes, right? So some of the things that make Florida special is our homestead exemption. So typically, properties that are homestead, they're exempt from probate. That's what those homestead protections are. So Florida law protects certain assets from creditors, like the family's home, which is called our homestead, up to 2 vehicles and up to $1,000 of personal property. Those are the things that the homestead laws here in Florida protect. If you have to go through probate, right? So now we're going to get into the part where everybody wants to really talk about how do we avoid probate, right? How are we avoiding probate? So the one thing that I say is that when it comes to certain accounts that you have, like let's say that you have a retirement account, investment accounts, bank accounts, savings accounts. The first thing that I have everyone, every person that I work with on when it comes to an estate plan is I always make sure, go ahead and list your beneficiaries with that financial institution, right? Because that's going to be key, because most of those type of accounts are payable upon death. So that means that whoever you're leaving in charge of your estate, they present the death certificate, and those things are payable once that death certificate is produced, right? So as long as those beneficiaries match with those financial institutions, your family won't have an issue tapping into those, tapping into what you've left for them behind, right? Now, when we're talking about property, now a will will not protect you or your family from going through probate. A will is just an extra layer of intent. It's an extra layer of intent. It gives your wishes. It lets you know. It's everybody. If anyone would contest, let's say with your bank account, your retirement account, your pension, and all of those things. Let's say you went and you did your due diligence and you listed all of the beneficiaries. Without a will. And so you have somebody in the family, they want to contest, like, oh, grandma didn't mean to put so and so on as their beneficiary. I'm gonna contest, with that financial institution, because that wasn't her true intent. Now, if you have that will that matches exactly what you put on place with the financial institution, account ending in 1234 goes to my cousin John Doe, and then at the bank or at the financial institution you have John Doe. There's your extra layer of protection, right? There's the extra layer of intent that the courts need to see in the event that someone contests something that you made when you were here, right? So that's number one. Number two, when it comes to a second thing that you can do is that you can put property and assets in a trust. Now, I know trusts are like the hot thing. They're like the hot topic. You get on TikTok, you get on Instagram, you get on YouTube. You have people that have never stepped inside of a law school telling you about a trust, right? When it comes to a trust, I don't care how great the internet template that you found is. Do not use it. Do not use it. Do not use it. A trust is not a one size fits all estate plan. Trusts are very very specific to each person's estate and then in their wishes. So when it comes to creating a trust, if one, you don't have a tax attorney, me personally, as an attorney, I would not create a trust for you. And here's why. Because when you create a trust, a trust comes with tax, there are tax ramifications that come behind putting together a trust, right? One, you have to have your trustees in place. You need to make sure that whoever you put in the form, put in the place of your trustee, that you can trust them, because they are going to be the ones that's in control of your assets. Now, they won't be the owner of the assets, because a lot of people don't realize that once you take property and put it inside of a trust, there's no individual that owns that property anymore. The trust owns that property. A trust is its own entity. It's almost kind of like having like an LLC or a corporation. That entity now owns it. So, if I were to create a trust, you know what I'm saying, the Keys, you know what I'm saying, the Keys Living Trust. Attorney Keys owns nothing. The trust owns everything. Now, during my lifetime, I can be the creator of that trust, and I can act as a trustee. But once I pass, I have to have a successor trustee in place. And that successor trustee is now going to step into my shoes when I'm no longer here. And they have a fiduciary duty to make sure that all of my beneficiaries are being protected, that they're protecting the trust assets. So that trust needs its own bank account. That trust has to have its own EIN. That trust is an operating entity, right? So I have every now and then I have a case that will come across my desk where we have a family that had a trust, and then now the trustees are stealing from the trust. And then the beneficiaries of the trust, they want to figure out what to do, because the trustee is not carrying out their fiduciary duties. They're doing whatever they want to do. They're withdrawing money from the trust account. They're selling off and listing properties, because that's a very real thing. And unfortunately, when you put somebody in place as a trustee and then you pass away, the trust can't be changed. So now your family is stuck with that individual that you've put in charge. And I know it's like, oh, well, I trust my family. But things get a little funny when there's money and there's property involved, right? So sometimes when I talk to people and I try to find out why they want to trust, the most common answer that I get is, oh, I don't want my family to have to go through probate. And so, after I have that conversation about them, how serious it is to put a trust in place, now they're a little scared to get the trust, because they're only wanting a trust because they want to avoid probate. So now I talk about different options of what can you do to avoid probate without having to create this huge responsibility for your family, and then you're no longer here to manage it once you pass away. So a couple of ladies mentioned it before we got started. Here in Florida, the term of art that we use is we call ladybird deeds. What is a ladybird deed? It's just a term of art that lay people use for an enhanced life estate deed. So what is an enhanced life estate deed, or was it a life estate deed? That means that if you own property, you can take title and have a life estate in that property. What does that mean? That means from the time from present day, when you first create that deed, moving forward all the way into your passing, you take the interest, you have a fee simple interest in that property, right? Only for your life. Now, once your life ends, you'll have something that's called remainderment. Those remainderment is who the property will automatically transfer to. So this is automatic upon passing. The property automatically transfer to your remainderment. Another way is that you can do a simple quick claim deed as well. Quick claim, you can have you have the person, if you want to make sure that you still have an interest in your property, you can do a quick claim deed, and you can keep your name on it, and then you can join it with whoever it is that you want to have that property. Now you can take title as tenants in common. You can take title as joint tenants with the right of survivorship. You never want to take title as tenants in common if you're trying to avoid probate, because tenants in common is going to trigger probate. Because what tenants in common essentially means is that each person on that deed has their own share of the property, and upon passing, it flows to their estate. So if Vivienne and I owned a property together, and we took title as tenants in common, that means that upon my passing, my portion, 50% of that property is going to flow through my estate, and then Vivienne, she'll keep her 50% of the property if she's still alive after my passing, and vice versa. With joint tenants with the right of survivorship, Vivienne and I, we both own the property, and we're both on title. Vivienne passes, the property automatically flows to me. I pass, the property automatically flows to Vivienne. So that, that's the most simplified way to avoid probate. Now, the one thing that I do want to mention is that if you do a quick claim deed where you're transferring title to different folks, or even a life estate deed in Florida, you are responsible for documentary stamps. So if there's an existing mortgage on that property, there's going to be a portion that the county, when you record it, that the county is going to require you to pay in addition to those recording costs. And it's always going to depend on the mortgage that you have on the property, and they use about whatever half of whatever that mortgage is. So if you have a $200,000 mortgage left on your property, and then you do a quick claim deed or a life estate deed, you do anything where you're transferring title, adding people to title, then it's going to trigger them to cut that mortgage in half. So it'll be $100,000, and then they'll do their calculation on how much you owe in documentary stamps to make that to make that change happen. Right. The other thing that I always encourage everyone to put in place now, this is kind of going off, it kind of goes right along with those deeds. I call them advanced directives. So there are other advanced directives that I always suggest that you put in place. Power of attorney. Power of attorney is super, super important. Why is it important? Because in the event that you didn't, put something in place, at least you do have a power of attorney where somebody that you trust, they can now handle your affairs in the event of your mental incapacity, your physical incapacity, anything. The other thing that I want everyone to put in place is a health care surrogate. Everyone needs to nominate a healthcare surrogate, because once you go into the hospital, the hospital may have some, they may have some forms and things of that nature that you can fill out. But what if your loved one isn't able to communicate so that they can allow you to be able to receive any medical information and things of that nature when it comes to their health? So you want to have those things already, put in place. So and then, like I said, the will is there to, like, it's an extra layer of intent to let everyone know what your wishes are. So that's pretty much that's my spiel on like probates and how to avoid probate. So right now, I'll open it up for questions. If you have any questions about anything that I've said, or if there was something that you were hoping to hear, you didn't hear it tonight, I can go ahead and address those things now. Yes, Miss Frida. You're on mute.
Yes, ma'am. Can you hear me?
Yes, I can hear you.
If you're in the state of Florida, and Florida is a joint domicile state, if something happens, say my spouse and I are married, and we both have kids before, I thought the way the law works in Florida is if I die, one of us die, everything automatically goes to the spouse if you don't have a will in place.
Right. So yes, if title was taken, if you guys took title as husband and wife or tenants by the entireties, yes. But what about that person that just took title as a married woman or a married man?
Mm-hmm.
Right. We don't know who they're married to. There's no other name on there, another name on there. So like absent, so that property would likely go through probate because they took title solely as the person, but just as a person that's married, but that name isn't on there. So it's important that if spouses are going to take property together, that they want to pass outside of probate, that they take it by tenants by the entireties, or husband and wife, or as a married, or as a married couple, because just taking title as a married person doesn't keep that property out of probate. You'll have to still probate it if you just take title like that.
Can I ask another question? So what if, like, the married couple, they die, one person picks you said someone to an executor, and the other person doesn't, and there's a will, would the person who's the executor be over everything if the other person, if the other married spouse doesn't have an executor or a will?
Okay, so when we say a married person, are we
So if
talking
I'm
about?
married, say I'm married to my spouse, I have a will and I have an executor, but the spouse chooses not to get one for, they just don't want to or didn't do it. How would that work if something happens to me and I do have the executor and a will and the other person doesn't?
So
There-
how do we take title as that married couple? Did you take it by yourself as a married woman, or is your spouse's name on the deed as husband and wife, or a married couple?
Spouse is on as husband and wife.
So then that's going to bypass probate, because remember, anytime you take title, anytime you take in title as a married couple, husband and wife and wife, husband and husband, any type of way where you and your spouse are both named there, and it's clear that you guys are married. You can have your own will. Everybody can have their own will, and you can name whoever the executor of your estate is going to be, and how you want your other assets distributed, right? Because again,
Okay.
a will is just an advanced directive. It's gonna allow us to pretty much know what your intent is. A will doesn't keep us out of probate. It's just that if we have to go through probate, we have a clear intent of what it is that you want, that you wanted prior to the transition. So married couples that take title together on the deed, it passes automatically. Now, a spouse that takes title to a property solely just as a married person, that property would likely still have to go through probate, and that will is going to help us.
Well, question, does it serve you, say, like, we're realtors, we have businesses, like our own business, does it help for us to get property in a business name so that no other family members can touch it if you buy it in a business name? Does that make a difference?
So as long if the business is going to keep owning the property, it means that there's no individual. So you better make sure that you have an operating agreement put together, and in your operating agreement, it talks about what's going to happen to any assets that are held by the business.
Okay.
Because that's what's going to govern when that's what's going to govern when we're talking about entities.
Okay. So I guess the question is, if I have the executor and the spouse doesn't, does my executor manage everything that we own together if the other spouse refused just to get the executor for their, to manage their stuff?
So it would depend on what assets belong to the marriage and what assets belong to you all as individuals.
Okay.
Because you can have marital assets, and then you can have separate assets, and so that's what's going to govern that. Like if you have a will and your spouse chooses to not have a will, well then their personal property, their personal effects, it's gonna fall under the laws of intestacy. Now we're not talking about property, because we've already determined that you guys have taken property together, and that you're taking property as a married couple. So that property is gonna transfer outside of probate. But as far as those other assets, it's gonna depend on if it's bank accounts, if it's savings accounts, if it's retirement accounts. It's gonna depend on how is that set up with that financial institution.
Okay.
Right. So it's going to depend on what's marital property, and then what's individually owned property at passing. So I guess the short answer to your question is that no, your will can't dictate your spouse. Your spouse's solely owned assets. Your will can't, because it's your will. It's the last will and testament of Frida Chambers. Right.
Correct.
Now, married couples can do a will together. But if you just made a will for yourself, and then your spouse made a will for their self, when it comes to their personal effects, then that's what's going to be followed when it comes to the distributing of those assets.
Okay. Yeah. Okay, thank you. I appreciate that.
For sure.
I have a question. It's a little bit of a twofer. So real life situation. I take care of my aunt who is up in age. She's in her early 80s. She's a victim of stroke, so she's convalescing right now in my home. She owns two homes. Unbeknownst to me, up until about this time last year, we thought because she owned her properties outright.
Somebody needs to put their phone on mute because I can no longer hear you.
Oh, sorry. I don't know. Somebody muted me.
No.
So I was basically saying this is a real life situation. My question is twofold. My aunt, who is elderly, she is convalescing in my home. Although I'm taking care of her, my aunt owns several properties, and I didn't know until this time last year that when someone, even though she's retired, she has pension, homes, Medicare can come and swoop that up, right? So we're in a situation now where we're going to have to open a trust in the family's name or her name. And I wanted to know like how, so one part of the question, the first part of the question is once we open a trust in the family's name or my aunt's name, I guess we would be beneficiaries or her children would be beneficiaries. And how do trusts hold up against both probate and entities such as Medicare, which is, I guess, the government?
So a trust is its own entity. So it is an entity. So you guys will only be beneficiaries of it. You know, whatever your aunt says, however she, you know, whoever she's going to have to be the person that puts the trust in place. You guys can't open a
She
trust.
can't. She is not mobile.
You're not going to be able to open a trust in because she has to be the person.
Okay.
Somebody have power of attorney, like to, you know.
Yes. My cousin, who was her first.
I don't know what the law. Like I said, I'm licensed in Florida. Yeah, so you know, in Florida, you know, the person has to. You have to, because when you do a trust, the creator of the trust has to be the one to sign it. You know, they have to be the.
So then that would be me then, because if that's the case, because they're about to transfer her properties to me, I have to create a trust for my own properties. How do I circumvent Medicare for coming out? You know, and then also once I've opened the trust in my name, how do I go about purchasing other properties in the trust name?
So just like you would put that property, as far as purchasing properties in the trust, is just a matter of how the deed is prepared, you know, and how you go under contract. Right. So whatever the contract says, that's who's purchasing, that's who's selling. So that's how you would do that. But, you know, I would suggest that you speak with a New York estate planning, attorney, just because when it comes to certain things, laws are a bit different. So I don't want to give you any misinformation, basing my knowledge off of, the way Florida does things. But like, as far as like Lady Bird deeds and stuff like that, enhanced life estate deeds, those things are kind of going to be like uniform across the board, no matter where state we're talking. But when we get to talking about trust, different states do have, that's why I said a trust is very serious business. It's not a one size fits all document. You're really going to have to sit down with your estate planning attorney and your tax attorney to make sure that everything is being set up properly so that you don't get yourself into any tax trouble. But I do know that a trust will protect any Medicare from coming in and trying to swoop properties. That I do know. But anything beyond the other specifics that you're answering, I'm not comfortable answering those questions because I'm not licensed in the state of New York.
In the state of New York. That brings my other question is, would you happen to have or be able to refer any New York-based attorneys?
Yes, I do. I do have a colleague that I work very closely with that is licensed in the state of New York, and she does probate and estate planning as well.
Oh, great. Okay, thank you so much.
If you shoot me an email, I'll send. If you shoot me an email, I'll send you her. I'll send you her information. That way, you can get in contact with her. Set up a consultation. Whatever her process is.
Oh, great. Now you did mention at the top of the call that your email address can be found on the first screenshot, but I went back and looked. It's not neither a screenshot. Can you possibly put your email in the chat picture so I
Yeah,
can take it?
I'll put that in there. Natasha,
I'm sorry, I didn't hear the last part of the sentence.
Vivienne said that she's going to go ahead and she'll drop it in the chat. It's on one of the slides that she had. So she
Yeah.
went past it. The email address is on one of the slides.
Okay.
But she's
I
going
didn't-
to put it
But
in the
thank
chat.
you. Thank you.
Attorney Keys, there's a couple questions in the chat as well. I can't see it right now because your slide is up.
Let me see. I can't. How do I? Okay, I see the chat right here. Let me see. Okay.
Can you see it?
Yeah, I'm so okay. I'm saying you may ask your
Can
questions.
you see the slide now?
What is the process for setting up a trust? The process for setting up a trust is one, having your tax attorney available, and then meeting with an estate planning attorney, and letting them know that you want to set up a trust. They'll likely have you fill out some type of questionnaire to get all of the basics of what assets you want to put in the trust, and then you guys will build that trust from there. The next question I see is if an unmarried couple is buying a home together, is right of survivorship the correct choice? Yes. If you're an unmarried couple and then maybe you plan on getting married in the near future, then of course, you definitely want to take title, as joint tenants with right of survivorship. However, if you are unmarried couple buying a property together and you don't know, and you don't know where the relationship is going, maybe you guys, you're still trying to figure it out. You might want to take title as tenants in common, because what that means is that if the relationship doesn't survive, then once you pass or the other person passes, their property just kind of automatically flows to the survivor of the two. And maybe that's not what you want. Maybe you want your portion, your 50% of the property to go to, your heirs and things of that nature. And maybe they want the same thing, especially if you're unmarried, because until you're married, you're really single. And so just make sure that, if you make the decision to purchase property with the non-spouse, that you're that you know what it means when you do right of survivorship. So that means that if this relationship just turns out bad and you guys forget to change title, well, you pass away, that person's going to get the other property, and your family doesn't have any claim to it.
Thank you. I have another question. You had mentioned that the trust needs to have its own bank account and EIN. I do have a trust already, a family trust set up, but
Yes.
I've not heard that before. So
Really?
we don't have a bank account our bank account is in the name of the trust. I think we did have to go change it over. That's our regular account. Does that mean that it's in the name of the trust has its own bank account?
Well, yeah,
So-
if the trust is on the bank account, then it's the trust's bank account.
Okay. And what about the EIN? I need to have a separate EIN for the trust?
I recommend, when I do a trust, I recommend that you have an EIN for the trust, because it's its own operating entity. There's not a person that owns anything. The trust owns it. The trustees don't owe the trustees don't own anything. They're just the fiduciary member of the trust that has all the responsibilities of making sure that whatever is written in that trust that benefits the beneficiaries takes place. But there's no person that owns anything. So I'm saying, if you're trying to purchase something in the trust, or do something with the trust, and you need a social security number, well, it's not any individual social security number. That trust needs to have its own EIN, which is that trust's social security number. So it needs to be set up, because a trust, like it's an entity.
Mm-hmm. So I could just apply for an EIN just like I would for a business.
Yep. EINs are free on the IRS's website.
Right. Okay. All righty.
But if you don't see, if you're not going to purchase anything with the trust or any, or anything like that, then it's not necessary. But you typically do have to have a bank account that has that trust name on it. I haven't heard of any trust being set up and it doesn't have a bank account with the name on it. So
Okay. All righty. Thank you.
my sister, okay, so I have another question here. It says, my sister and I own a property together. My brother passed in February. Do we need to probate? We are joint tenants. You, your sister, and your brother were all on the deed as joint tenants?
Yes, we are all on it as joint tenants. He passed.
Okay, well then that means that if you all took title as joint tenants, property passes outside of probate. But it needs to have those words, joint tenants, right of survivorship. If you don't see those words on the deed, then you did not take title as joint tenants.
I'm not really sure if we're joint tenants or not, but I do know that once he passed, it was just left to me and my sister. So I don't know where it's at. But
You're only going to know that once you look at the deed. Now, if you pull up that deed right now and you don't see anything that says joint tenants, then you did not take title. It don't matter if you guys took title all at the same time. If you don't have those magic words, then it's tenants in common. If you don't have anything, it's tenants in common. So, the default when you take title is tenants in common, unless you put tenants by the entireties, husband and wife, a married couple, joint tenants with right of survivorship. If you don't see those words, then it's tenants in common.
Well, my dad really left it in the will stated like that.
So a will is not going to be controlling. Remember, we talked about that. A will is not going to be controlling when it comes to avoiding probate. A will is just an extra layer of intent. So even if the will says we want the property after this person passed, there has to be something else in place to make it bypass that court procedure. Because that's what probate is. Probate is a way of taking property or assets out of the deceased person's estate and passing it on to the beneficiaries. In the terms of property, if you have a deed that's already if you already have a deed, each person listed on that deed as the grantee. If it doesn't say married couple, husband and wife, tenants by the entirety, joint tenants with the right of survivorship, that language is really important. Then it's tenants in common.
Okay. Yeah. Yes. The lawyer, he wasn't a probate lawyer. He said he didn't know, but he was a lawyer that was handling the will part. Yeah. So what he said, follow up with a probate lawyer. So I guess we do need one.
Yeah, the simplest way is to just pull that deed up. You know what I mean? Because even lawyers, we just people. We make mistakes. It's a mistake of just leaving that language off of the deed.
Okay.
It doesn't matter what the will says. Matters what the title says. And title is just another way of saying deed. Whatever the deed says, that's what controls, not what the will says.
Okay.
Because wills don't keep us. Wills, remember my little pun earlier. Wills will not keep us out of probate.
Okay. And you say it have to say, the deed needs to say tenants.
It needs to, if we're taking title as joint tenants with right of survivorship, it needs to say joint tenants with right of survivorship. Okay. I don't recommend, and me personally, I don't recommend anybody finding a deed online and putting it together yourself. It seems simple enough, but you wouldn't imagine the mistakes that I found on deeds from people just trying to save a buck, and then ended up having to pay thousands to get something fixed when they didn't do it correctly. So even if it's something as simple as a 2-page deed, a quick claim deed, don't try to do it. Don't try to do it yourself, because even if you got the best template in the world, it's not what you do. So you can easily make a mistake. You can make a mistake in the legal description. You can make a mistake in the way that you made somebody take title. And then, once people start passing away, you can't change it. It's kind of set there. And once it's recorded in the public record, if you don't know how to fix the mistake that you made, you're just
Right.
gonna make another mistake trying to fix it. So, to me, it's better to spend a little money on the front
Right.
end to
Yes.
avoid a huge invoice on the back end.
Yes.
Trying to do something yourself that you're literally just legally not trained to do.
Right. Thank you. I'm gonna follow up with you. Thank you.
Yes, ma'am.
Before we go, I wanted to also, a question came in when you just said what you said. I personally will be hiring an attorney to do this. But I also wanted to say, or ask rather, since now I know that the trust is its own entity, much like my LLCs, because it comes with its own EIN number, etc.
It
Can
don't
you
come with it.
go
It
on?
don't come with it. You gotta get it. It don't come with it.
No, I know what you mean because
Okay.
I know how to set up LLCs.
Okay.
But having said that, just like I could do a search for LLC or corporation on the Secretary of State website, is my trust name and the information, or just the trust name alone, is that public information that can be searched on the Secretary of State website, like
No,
LLC or corp?
no. Now again, you're in New York. Florida, you know what I'm saying? Florida, we don't register trust, with some biz, which is the operating engine that we use to file our things on the Secretary of State. There's no requirement to do that. There's no requirement to record your trust in the state of Florida. I don't know what the laws
Mm-hmm.
are in New York. So I don't know how, I don't know what they require you all to, what they require. If they require you to put it on the Secretary of the State, then the answer is going to be yes. But I know in the state of Florida, we don't create trust on some biz. Some business for, LLCs, limited partnerships, and corporations. We don't, there's no way to even open up a trust on some biz.
What is Sunday?
Some biz is what we use. That's our Secretary of State. That's how, if you're going to start an
Oh,
LLC,
really? Oh, okay.
it's
Because
called
when
somebiz.org.
okay. So I work in every state almost, and definitely have worked in Florida. So I just Googled Secretary of State and the name of the state. I never noticed the name of for Florida was Sundays. Okay.
Somebiz.org. Mm-hmm.
Okay. I only say that because what you say is true. This is not something you just want to get off of the internet and print, because I just found out something very scary recently. There are people in the country, and hopefully nobody's fallen victim to this, people who outright own their properties, and you have fraudsters literally taking their homes right from under their nose, to the point where now many states, Florida, New York, and others, have now an alert system that will alert you via email and supposed to be via regular mail to let you know, hey, somebody has said that, either you sold your house to them, you refinanced. It's all kind of foolishness.
Well, that it's the truth, right? Because what is a deed, right? It's a piece of paper.
Right.
It's a piece of paper that can be created by anyone. So if someone knows your address and they're savvy with the property appraisers website, they can literally go on there. They can create a deed, and they can
Right.
transfer the property and record it electronically. What we call, that's called a wild deed. That's what that's called, a wild deed. And now you have to essentially prove that this deed is fraudulent. So
Right.
that is a real thing. So that's why, I always recommend, when you're doing estate planning, you always want to just kind of, like at least once a year, once a quarter, just go to your property appraiser's website, go to your tax collector's website, make sure that things are, that things are still in place. Make sure that the property is still showing up in your name on the property appraiser's website. Make sure the property is still showing up in your name on the tax collector's, website. Have identity alerts and things of that nature, set up so that you are alerted, if someone tries to, do something fraudulent when it comes to you and your property.
Thank you so much. You've given such a wealth of information this evening. I'm sorry, I'm out here hiking and multitasking while listening. So.
It's quite all right.
I have a
Thank
question.
you. Yes.
Now, it does relate to Georgia, but if you know anything about it, I would appreciate whatever information you can give. So a person dies, they have a will, they left an executor of the will. Is there a time period within which that executor should basically finalize that will?
So all wills are governed by statutes, whether it's in Florida, whether it's in Georgia, or any state that we're in. As long as so a will, again, a will is just it's an extra layer of intent. It just kind of lets us know what your wishes are. It's not one of those things that's gonna determine if we go to probate or not. It's gonna help us in probate. Have to go, but it's not going to keep us out of probate, right? So even in Georgia, you can still put those things into place. We talked about the life estate deed, or a quick claim deed, where you're taking title as joint tenants with right of survivorship. That's a proper designation for the state of Georgia as well. I'm actually in Georgia. So my law firm runs and operates in the state of Florida. I have a paralegal, and I have a small team that works. I recently just sat for the Georgia bar a couple of weeks ago, so I do plan to have my Georgia license here here shortly. So
So this
I
is
do
an actual
know quite a bit about Georgia.
This is an actual scenario. This is an actual real scenario right now where the person died in 2013, and there is a will, there is no trust, but I and I don't know if this really is something. The will was passed through probate before the person died. And there's an executor of the will, but the will, nothing has been done thus far with the will. I mean, it's still with the executor. Nothing has been done. The person who died, the children's names are on the will. At least for like the property, they should be taking over the property. But nothing has been done thus far. And actually, to complicate things even more, the property experienced a fire last year. The insurance is giving the money to the executor of the will, but that person is doing what they want to do in terms of repairing the property. So they're repairing the outside, they're fixing they're making changes to the outside of the property, but not repairing the inside that was damaged by the fire. So complicated, but I'm just wondering if you have any idea on,
So with this scenario and any scenario, what I always like to know, what does the deed say? What does title say? Because that's going to let me know, what position the estate is in, right?
The title is in the name of the deceased.
Solely?
Yes.
Okay.
But the will has the deceased children's names on it.
But remember what I said, a will is just, it just kind of guides us through probate. So right now the state still owns that property. No one owns that, no one owns that property. So, if you have family members or individuals, making changes, they're just kind of doing what they want to do, but it doesn't sound like there's been any movement of the property coming out of the estate of the deceased to be transferred into any beneficiaries. It sounds like that the probate needs to be finished and completed, because at the end of the probate, you're going to have like a personal representative's will, or an executor's, not will, a personal representative's deed or an executor's deed. And what that pretty much says is that the court proceeding was opened. Is all of the proper legal documents have been filed, with the probate court in that county, in that county and in that state. And then the judge has issued a final order that says that it's okay to transfer the property from the deceased person's estate to whoever the beneficiaries are. That's when the will come into place, because whoever that probate attorney is that, they're going to cite the portion in the will that's that points to who is this property going to be passed to once this probate is over. And that's
Who
what
starts the process, or how does the probate process get started? Do they need to contact an attorney?
Yeah. You can try to do it yourself, right? Is it required that you have an attorney to do your probate? No, nothing in this life requires you to have an attorney. It depends on how efficient you want things done, because you're only going to be able to Google so far,
Okay.
to get a probate done, because
Mhm.
you don't know the different statutes that have to be quoted within, within the documents that have to be filed. The first thing that has to be filed in any probate is that you have to have the petition. The petition to open up the probate administration. And then once that petition has been filed, then you have to appoint that personal representative or that executor. And again, that's something else that has to be filed with the court, and the judge has to pretty much sign off on those things to say that, okay, the probate is open. Here is your personal representative or executor of the state, and it's going to be that person that's going to carry out all the duties to get us to the end, so we get that final order. And then it allows that one person to sign on behalf of all of the beneficiaries, when there's a will, to make sure it goes to those named beneficiaries. If the person passes away without a will, they pass away intestate, and so then the laws of that state will govern how the property is passed.
All right, last question. I just want to be clear on this. So you have you have a will, you have an executor of the will. The executor is not one of the beneficiaries, no,
They can be.
on the will. No, in this case, it's not.
Okay.
So who starts the probate process? Who finds the attorney? Is it the beneficiaries or the executor of the will?
It can be a combination of the two. It's really kind of up to the family. To me, I always like for the family to be on one accord. Beneficiaries and the person that's the personal representative, in my opinion, you should all have the same attorney. Now, sometimes, the personal representative gets their own attorney, and then the beneficiaries gets their own attorney, just to make, just to kind of, like, I guess, whatever checks and balances. But if the entire family's on one accord, the process goes so much smoother. So, it's whoever wants to find the attorney, but any individual can get their own attorney to make sure that they are being protected throughout any process.
And when will you be available in Georgia?
Well, I'm available in Georgia right now. So how I do things now is that, because I'm not licensed, but I do know how to prepare all of the documents. I do consultations, and I can consult you through a probate process as a pro se litigant. And what a pro se litigant is that, you're pretty much doing it on your own. But I would draft all of the documents, but you would be the one signing them and filing them with the courts.
I see. Okay, thank you.
So Attorney Keys, there's a question about quick claim deed in the chat.
Okay, let's see. Let's pull it up. I'm not gonna pull it up. What's that? Well, let me pull up I'm trying to pull up the chat.
It said, please give a little information about quick claim deed.
Okay, so just, and this is not a big deal, but it's not a quick, like we running fast claim deed. It's a quit.
Q-U-I-T.
Q-U-I-T claim deed. Right. So when you say give a little bit information about a quick claim deed, so a quick claim deed is like, it's a deed that is prepared without the evidence of a title search. There's no evidence of anything. It's really just a deed that that's put together, so it doesn't travel with any protections. So if you're going to receive a quick claim deed from any person, or you're going to prepare a quick claim deed, just know that it's not traveling with any protections. Like I was speaking with the young lady earlier, like how I was saying, is that it's a piece of paper that can be drafted by anyone, and then it can just be filed in the public record. So a quick claim deed is exactly what it sounds like. It's a deed that's prepared without any evidence that the person that you say owns the purported owner of the property. We don't know if they're really the owner of the property. Now you can go and check these things, with the property appraiser's website, tax collector's website, and you can make sure that that's what happens. But it's just a variation of the deed. You have different types of deeds. You have warranty deeds, right? A warranty deed is going to travel with 6 warranties, and it pretty much protects you as the receiver of that property from, you know, anybody making claims to the property now and in the future. Your covenant of quiet, quiet enjoyment, which means that no one can just, you know, kind of walk onto your land and say, hey, this is my land. So it travels with all of the protections. A special warranty deed is going to travel with all of the protections as a warranty deed. It's just a special warranty deeds are typically from builders to whoever's purchasing that new property. Then you have personal representatives deeds. Those are going to travel with the same warranties as a warranty deed. A life estate deed is going to be you as the person that has the life estate in the property. You only have title to the property until your life ends, and then the property goes on to the remainder men. And then you have the, you know, like I said, the deed with the lease. And a life estate deed has those same warranties as well. Right, travels with all those protections. And then you have that quick claim deed. You know, it's a quick deed. It's which is why people get it mixed up with quick claim deed, but not quit claim deed. It's a fast way to transfer property, outside of, having to do a title search and all of those things. I hope that answers the question.
That's good.
I have a follow-up question to that last question you answered. So if you're looking to purchase a property, let's say you're looking to purchase an investment property, and it says it was acquired, the existing owner acquired it via a quitclaim deed. Does it mean that when you purchase that property, let's say there's a lien on that property, are you inheriting that lien? Does it have anything at all to
Well,
do
it
with
depends on it. It depends on the process you take in acquiring it, right? So, are you getting a title search? Are you going through an attorney that does closing? So my office, not only do we practice real estate, we also I'm a licensed title agent, which means that I run title on property. So, I can see anything and everything that's attached to a property. And then what I do prior to a closing is that I clear the title. Once I clear title, that allows me to issue a warranty deed at the end of that transaction. Now, some people, they don't want to do that. Some people just want to, hand over somebody some cash. They don't want to have to pay for a title search. They don't want to have to go through a full-on closing, because when it's cash, there are no guidelines, there are no guidelines really, like when we're doing like a regular purchase and sale that has a loan attached to it. If you're purchasing something in cash, we can literally put together a contract, do a settlement statement. If you want money to pass through escrow, it can, or if you want to give this person a check, you can. And then what my job will be is that I would just prepare that. I'll prepare that settlement statement for you, and I'll prepare that quick claim deed for you. But if you go through the process of getting the title search and all of those things, then you'll always get a warranty deed. So a quick claim deed is only issued when there's no evidence of any type of search being done on the property. Now, you can just purchase ownership and encumbrances report, which is the same thing as a title search with in a regular transaction. However, even if you do a title search, you don't get a warranty deed if the process of clearing title doesn't take place. So there's a couple of ways that I can answer that question. So yes, you will inherit that lien if you purchase the property without the evidence of a title search and don't go through the closing process. No, you won't inherit that deed if you go through the process of ordering title and then going through the full closing process and allowing a licensed title agent to clear the title to that property, which means that at that closing, before that person that's selling that property, whatever their proceeds would be, any monies that have to be due to clear any liens, any easements, any encumbrances will be collected and deducted from their final portion that they will receive at the end of that transaction.
Thank you.
And I know in the state of Georgia, in the state of Georgia, Georgia is not a title state; it's an attorney state. So typically, when you're doing any transactions that involve real estate, you are required to get an attorney to assist through that process. In Florida, it's a title state, so any licensed title agent can clear title and perform closings.
Thank you.
I see some stuff in the chat. Okay. All right. Anybody have any more questions?
Yes, Attorney Keys, can you just review about the Tennessee and commons, the Tennessee and rights? Because for me, it's a little bit difficult because sometimes what one title says, it's not specifically that. There's one that's kind of tricky. So can you just review those so that, it'll bring more clarity to those tendencies because I know they're important. I'm a student of real estate, so that's okay. Thank you.
Yeah, for sure. So I'm only going to be talking about Florida because that's where I'm licensed. So we have tenants by the entirities, right? That's one way that you can take title. Tenants by the entirities. What does that mean? It just means that you're a married couple. That's the designation for married couple, like people that are married. Tenants by the entirities. Husband and wife, a married, you know what I'm saying, like you and your spouse's name, a married couple has the same effect as tenants by the entirities. So all of those are the same.
Okay.
Okay. Then you have joint tenants with the right of survivorship. Joint tenants with the right of survivorship. That's gonna be the designation for individuals that are not married that want to take title as joint tenants. So both joint tenants and tenants by the entirety. When any person that has title with you to the property passes away, the property automatically, outside of probate, transfers to the survivor. But you have to have those things written. If those things are not written, let's just say that if I'm married and my spouse and I, so my name and my spouse's name, and then I don't put anything, but I know we're married. You know what I'm saying? We know we're married, but the title doesn't say that. By default, tenants in common.
Okay.
If you don't say anything, it's tenants in common. If it's just names listed on the on title, it's tenants in common. It has to say joint tenants with the right of survivorship. It has to say tenants by the entirities. It has to say a married couple. It has to say husband and wife. It has to say husband and husband. It has to say wife and wife. It has to have any of those it has to have those specific, it has to have that specific language in order for you to have title where it passes outside of probate. When any person that's on title, the survivor inherits the property automatically outside probate. Tenants in common, it's going to pass through each person that's listed on that title's estate separately.
Okay. Thank you.
Welcome. Do we have any more questions?
Any more questions? We're at about 7:39. We're about an hour in now. So if we have no more questions, we're going to thank Attorney Keys for her time and for answering all those questions. And it's a wealth of knowledge we had tonight. What a chat this was. What a chat this was. Attorney Keys, we so appreciate you. Very informative information. Very informative information.
Gratitude.
Yes. So I put Attorney Keys information in the chat. So if you have any other question for her, you need a consultation, you need help, you need a referral, reach out to her and she'll be happy to assist you. Yeah, it was really, 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 Attorney Keys, I really appreciate your time. This was like, yes.
Thank you for
Any last word, Attorney Keys? Any last words?
I just, thank you all for, taking, the time out of your day to, to spend it with me, to trust me to answer these, really sensitive questions. I really have a passion for this. At the end of the day, I'm a servant, right? This is, that's why I became an attorney. So, my main goal is to help people. So, if you need help, let me know. Don't find yourself in a situation where you're trying to do something on your own, because it's just not, it's not worth it. It's not worth it to, make a mistake that could be detrimental. It just ask somebody, just ask for help. I'm here to help. You can, like, just reach out to me, at the end of the day, I do have consultations where if you want to, have a little bit more time, you want to spend about an hour or so with me, I do have those options, available. Or if you just have like a quick question, I can answer that, on the fly.
Thank you so much, Attorney Keys.
Thank
Yes,
you.
thank you so much.
Thank you.
Thank everyone. Thank Attorney Keys, and thank you guys for showing up. Thank you
Thank
guys for
you.
showing
Very
up.
good information.
I
Do
Thank you.
me
appreciate
a
you
favor,
guys. Thank you
if
for
you
the
have
support.
Instagram, if you have Instagram, you can follow me on Instagram at Attorney Keys. I do put out videos from time to time, that just kind of answer, they just answer questions that, that I think people may have when it comes to estate planning and things like that. So, give me a follow, I'll give you a follow back. I'm on TikTok as well as Attorney Keys, as Attorney Keys as well.
Thank you.
Thank you.
Have a good one. Thank you so much.
Thank
I'll be
you.
following you on both
Yes.
platforms, Attorney Keys.
Thank you so much. Thank you. I appreciate that. Gratitude.
I would definitely follow you
Thank
also.
you.
Great information. I would definitely pass your contact information along to anyone who's looking for a good attorney. Thank you.
Yes,
Awesome. Awesome. Thank
and
you.
Ms. Frida, you said that if you're I believe there were some realtors in the chat. So you can also partner with me as well for your closings. So like I said, I am a licensed title agent. Vivienne and I, we close deals together all the time. So very rarely is it's very rare that you're able to get, if you pick up a phone and you dial a number, the attorney answers the phone. I answer the phone here that way, because I want to be the first person that the new potential client speaks to. So you don't get a legal assistant, you don't get a paralegal. 9 times out of 10, when you make the initial call to my office, you're going to speak to me, right?
Awesome.
So that's one of the things that I pride myself on, is being available for new and for my new and current clients. Is that you dial that number, you're gonna get me on the phone, right away to answer a question. Now, if I can't get to you right away, I will call you back, and I'll likely just shoot you a text message like, hey, give me a second, I'll call you back. But I do take the time to talk to all of my realtor partners, my clients, and everything like that, and when it comes to Florida, so I'm licensed in the entire state of Florida. So it doesn't matter if you're up north in Jacksonville, or if you're down below in Boca Raton, or if you're right here in the middle, or Tallahassee or Orlando or Tampa. It doesn't matter. Any county, every county, I'm licensed to practice law in those counties, and I do travel for my clients.
I will
Thank
definitely
you.
be